Hey everyone, good afternoon. Happy Friday. Um, I hope you guys have had a really good week so far. In Boston, it's been really cold, so I hope the weather has been a little bit better where you are. For those of you that are new, my name is Attorney Bianca Jordan. I'm an immigration attorney in Boston. A couple of days ago on my Instagram, which is Brazen Lawyer, in case you're not following me over there, I asked people if they had any immigration topics or questions that they wanted me to answer on this week's live. And the majority of the people that actually answered the sticker that I put up on Instagram said that they wanted to know what the process for adjusting your status through a spouse looked like from start to finish. So this video today will focus on that. So before I get started on that, I just want to remind you guys that the public charge rule, the new implementation of the public charge rule, goes into effect on Monday. And so if you're interested in applying for a green card, or if you've already started the process tomorrow, which is Saturday, February 22nd, would be about the last day that you could mail your application to guarantee that it would get to USCIS by Monday. There's obviously the possibility of overnighting it on Sunday night to make sure that they get it on Monday. It has to be postmarked before the 24th. So if it's at all possible for you to get your green card applications out in the mail tomorrow, that would be your best bet. After Monday, the process gets a little bit more difficult. Last week's episode was on the evidence that you will need to submit with your applications going forward. So if you have any questions about the new implementation of the public charge rule or the evidence that you'll need to start submitting with your application packets effective Monday, you can definitely check out those videos. All right, so getting a green card through adjustment of status through your spouse. So first, generally speaking, there are two ways in which to get a green card. The first way is through consular processing, which means that you are getting your green card outside of the United States. It means that you are getting your green card through your embassy. So you would need to go back to your home country, and you would go through an interview at your embassy, and assuming everything goes well and your application is approved, you would receive your green card there. The other way in which to get a green card is through adjustment of status, and that's what this video will be focusing on. So I'll be focusing on adjustment of status, which means that you are adjusting your status to a green card from within the United States. So you don't need to leave the United States to get your green card. In order to adjust your status, you have to meet these three general requirements. First, you have to have been inspected, admitted, or paroled into the United States. Generally speaking, that means that you came to the United States through a border, you were inspected by an immigration officer, whether it's, you showed them your visa, your passport, or something. If you didn't have papers and you came through a border, it's likely that an immigration officer would parole you in. So as long as you came through a border, an immigration officer, inspected you and admitted you into the United States, then you're eligible for adjustment of status. The second criteria is that you have to be admissible to the United States. And basically that means that you don't have anything that is keeping you from being able to come into the United States, such as certain diseases or medical issues, criminal histories, a prior deportation, things like that. There is a really long list in the Immigration and Nationality Act, which is our immigration law, that details things that make you inadmissible. One of those things, as we've discussed before, is the public charge rule. That's one of the grounds of inadmissibility. So assuming that you are inspected, admitted, or paroled into the United States and you are admissible to the United States, the third criteria that you have to meet in order to adjust your status is that you need to be an immediate relative. And an immediate relative for immigration purposes is a little bit different than what we would expect. You're probably thinking your immediate relatives are your siblings, your spouse, your children, your parents, but that's not the case for immigration purposes. So if you are applying for a green card, you are an immediate relative if the person petitioning for you is a US citizen. So immediate relatives are relatives of US citizens, and it's not all relatives. The only people that count as immediate relatives of US citizens for adjustment of status purposes are spouses, parents, and unmarried children under the age of 21. So if you are someone's sibling, if your sibling is a US citizen and they're petitioning for you to get a green card, you're not an immediate relative, so you would not be able to adjust your status from the United States. You can still get a green card through a petition from your sibling, but you would have to go through consular process and you cannot get it through the United States. Similarly, if your relative has a green card, and if your husband has a green card and he wants to petition for you to get a green card, you're not an immediate relative because your husband's not a US citizen. So if your husband files a green card petition for you, you would need to go to your consulate in order to get your green card. So as long as you meet those three general requirements, you are inspected, admitted, or paroled into the United States, you are admissible to the United States, and you are an immediate relative, you can apply to adjust your status. So what does the process look like? If you're in the United States, you can file all of your immigration documents at one time. So you would submit your green card petition packet all at once. And so you would submit this depending on where you live. You would submit it to USCIS, which is the United States Citizenship and Immigration Services, and you would submit this application based on where you live. So for example, if you live in Massachusetts, you would submit it to the Chicago location. A couple weeks after you submit your application, you'll receive a receipt notice in the mail if your application is accepted. Having your application accepted does not mean that it was approved. It just means that USCIS got your application. They went through the whole packet to make sure that everything is there, that all your pictures are there, all your T's are crossed and all your I's are dotted and all the check boxes are checked off and all the signatures are there. They're just making sure that everything looks in order and they've accepted your application, and now they're going to send you a receipt notice just acknowledging that. And on that receipt notice, you will be given a receipt number, which enables you to track the progress of your case. A couple weeks after that, you'll receive another notice in the mail, which is for your biometrics appointment. And your biometrics appointment is basically where you go to immigration, you go to a USCIS field office, and you go through your fingerprints and your pictures. The appointment typically lasts anywhere from like 15 to 20 minutes, and you just go in, do your fingerprints and pictures, you're good to go. After that, it's really just a waiting game. And the process to get a green card really depends on where you live. It could take a year and a half to get a green card through your spouse. It could take longer if there are issues with your case. It could take shorter if there are no issues with your case, and if the location that your application was sent to doesn't really have a big backlog. And while you're waiting, a couple of things could happen. If immigration needs more information about your case, maybe they need a little bit more information about your financials, or maybe they want another copy of your birth certificate or something like that. They can issue something called a request for evidence, or an RFE for short. And if you get a request for evidence, you have a very limited amount of time to respond to that request for evidence. So if you're not sure what it means, if you're going through this process without an attorney and then you get an RFE, I would recommend contacting an immigration attorney as soon as possible, because you want to make sure that you are responding to it correctly and in time. I have seen people that have tried to do this on their own, and they have had their applications denied because they didn't know what immigration was requesting, they weren't really sure how to respond, or they just didn't respond at all, and so their application gets denied and you lose that fee. The RFE can request a variety of information. So it could be something as simple as, we need another copy of your birth certificate, or it could be as simple as, or complicated as, we need more evidence of this relationship. But each RFE is different, but like I said, you have a very specific period of time to respond to it. And then once you respond to it, USCIS can take anywhere from 30 to 60 days to review the information that you have submitted to them that they have requested. Once that goes through, you will get your work card. It used to be that you would get your work card a couple weeks after you had your biometrics appointment. But one of the things that this administration has done is it's changed how you get your work card. So you no longer get it early on. You get it, typically we've been seeing that clients are getting their work card a week or so before their green card interview. So you won't get your work card until a little bit later in the process. And then it's about preparing for your interview in that time frame. So gathering any additional documentation, maybe when you submitted your green card application before you didn't submit everything with the application. So maybe you want to start gathering a little bit more information to prove your relationship. So you can start to do that during the waiting process as well. And then at your interview, you're going to go into the office and you're going to check in with the officer, have a seat, and wait until your name is called. They may call the petitioner first. They may call the U.S. citizen petitioner first. And so you'll stay behind and your U.S. citizen spouse will go in. He'll go into the USCIS office. The officer will ask for his ID, so definitely make sure that you're bringing in your passport or your driver's license, something to show your identity. And then once the officer checks that, they are going to swear you in. So you're going to have to raise your right hand and say, you swear to tell the truth and all that stuff, typically like how it looks like when you are watching court TV shows. And then they'll go through the application with you and start just to verify the information. And then they'll start to ask you questions about your spouse. Once that portion of the interview is over, the immigration officer will call in the spouse and go through the same thing again, checking your ID, swearing you in, going through the interview, asking your questions. If at the end of the interview, the officer is satisfied that they believe that this is a bona fide marriage and that this wasn't just a marriage to get a green card, your application will be approved. And depending on where you live, you'll get your green card within, I've seen my clients get a green card within 7 days. Others, it might take a couple of months. If the immigration officer is not convinced that this is a bona fide marriage, or maybe they are convinced it's a bona fide marriage, but because there were so many inconsistencies in some of the answers between you and your spouse, then the immigration officer might either say that they need to do more research into your case, and so there might be like an investigation lodged to make sure, maybe they want to do a little bit more research to make sure that this is actually a valid marriage. Or they might give you the option to withdraw your application to avoid all of that stuff. And if you do withdraw your application, you'll get a letter in the mail saying that, your application's been denied, and then you can just apply again at a later time. That's generally the whole process from start to finish. If you have been married for less than 2 years at the time that you file your green card petition, then you will get a 2-year green card. And then once you get your 2-year green card, about 90 days before your green card expires, you have to apply to remove the conditions on the green card, and you're basically doing this whole process over again. And then you go back to immigration, and this time they're just checking to make sure that the marriage is still intact, it's still valid, and there are signs that you're still intending to live together as a married couple. And assuming all goes well that time around, you will receive a 10-year green card. So that's the process from start to finish. As I mentioned earlier on this video, the process is changing a little bit starting on Monday. There will be more information that will be required for your green card petition if you are subject to the public charge rule. And since immigration is just changing left and right, there are so many different changes, so much more information that is being required and requested as part of this application. I strongly encourage people to work with an immigration attorney that knows what they're doing. I unfortunately have seen situations where people try to do the green card petition on their own, thinking it's just filling out forms, and then maybe they receive an RFE and they don't know how to respond to the RFE, so they don't, and now their application is denied. And at best, they're able to just apply again. I've seen that happen to people, and they're able to just reapply for a green card. They do it right the second time around with an attorney. Their application gets approved. They live happily ever after. I've also seen really bad situations where people go through the green card process on their own, their application is denied, and then they don't refile, or they don't hire an attorney, and then something goes wrong and they end up in removal proceedings. I've seen that as well. So I strongly encourage people not to take the risk anymore. Immigration is more complicated, it's more difficult. Even the questions that they're asking at these interviews are a little bit tougher. The interviews are a little bit more antagonistic, and so it's really in your best interest to work with an immigration attorney on your case, an immigration attorney who can prepare the application packet correctly, who can prepare you for the interview so that you're not as nervous and you know what types of questions to expect at the interview, and someone who could represent you on the off chance that something does go wrong and you find yourself needing a waiver, or maybe you find yourself in removal proceedings or something that maybe wasn't anticipated, but at least now you know that you'll be okay because you have an attorney present. So I hope this video was helpful. is a little bit longer than I expected it to be. I really just wanted to hop on really quickly on this Friday and just answer the common question that I got in my Instagram poll a couple days ago, which is really just what does the process look like from start to finish? It might seem like it's not that difficult. It's just filling out forms, sending in paperwork, but it's a little bit more than that. And especially where your freedom is at risk, really. And so I think that it's better to just work with an immigration attorney. I have seen people and been contacted by people who wanted to maybe cut corners or maybe cut costs. And so they tried to do their green card application on their own, and then it gets denied, something goes wrong, and now they're in removal proceedings, aka deportation, and now they have to pay even more money. So they end up paying way more money than they were trying to save in the first place. So it's really just better to, from jump, just work with an immigration attorney on your case. Make sure that it's done the right way. And if anything does go wrong, at least you already have an attorney working on your case that can jump in and continue to guide you through your process. I hope you found this video helpful. If you'd like to learn more about me and my law firm, you can visit brazenlegal.com/contact. And you can also contact my law firm at 508-942-7497. You can also send me a message, or I use WhatsApp. My clients are all over the world. I have clients in Haiti, Italy, New Zealand. Like, I have clients all over who are trying to come to the United States or trying to help their relatives immigrate to the United States. So I use WhatsApp a lot. So you can send me a message, you can call me on WhatsApp. And again, you can send me an email. You can visit brazenlegal.com/contact. Thanks for watching. Have a great Friday.